Hello, everyone. Welcome back. Welcome to the Sweeney Show, Business and Law Podcast. I'm David Sweeney, and joining me here today is Mr. Rodney Peyton, trauma surgeon, medical negligence expert. Mr. Peyton, you're very welcome.
I appreciate that. Thank you for asking.
Are you based in Northern Ireland, or where are you calling from today?
We're based in Northern. We live probably half the time in Northern Ireland. Then we have a home in Tampa, in Florida.
Oh, lovely.
So we're there, and then my children are scattered around the world. One in Cork, actually,
Okay.
and the other one's in Australia, and another one in Charlotte, North Carolina. So we travel for them. We live part-time in Treasure Island and Tampa, and part-time here.
And you're a medical negligence expert, which is probably a lot of the topics and subjects we're going to discuss here this morning.
Sure.
We do some medical negligence here in my firm, and we find that part of the skill, I think, is that the word I'd use, for a solicitor to take on a case is picking cases that we believe actually have negligence in them. Because we find that a lot of the inquiries involve maybe birth injuries to mothers or any kind of, surgery that it might have been a very traumatic time for the person, but it doesn't necessarily mean a negligence occurred. The surgeon or the midwife or the doctor consultant may have made a decision on the day, had a consequence for the person, but it was needed to maybe save their life or prevent something else. How do you, as an expert, decide a case is worth pursuing?
Well, you have a look at what your client has said, and you're looking for the holy triad of duty breach but for a consequential damage. And sometimes you can see quite clearly when you're looking at it, it's there or it's not. And remember, about 5-6 of all of these cases that come in are defended. That's the MDU figures and my own figures from thousands of these. So you take what they say and then dissect it to look at their duty breach and consequential damage. That's why we do screening to begin with. Before you spend a lot of money on very expensive reports and detailed reports, you want to get a screening looked at. Some lawyers have a background in medicine, but maybe not up-to-date medicine. Others do not. So it's wise really to have someone on your staff who looks at these routinely for you, or, the one-off, but to find someone who will screen it for you, look for duty breach and damage. And then you get three things. You get a red light. It's not going anywhere, obviously. You get a green light, said, oops. And then you get an amber in between, so I really don't know. Need to have a depth look at the notes and records to see really what's going on there.
And it is a screening like a preliminary report? Like
Yeah.
how would is that done on just the client statement, or do you need records to do that, or how is that put together?
Client statement and brief records, and usually a lot of it's done oral because it's for advice. My job is to help the clients, their lawyers, and at the end of the day, the court, to more clearly understand the nature of medical evidence in a particular case so they can come to better decisions. It's not my job to make decisions on it, but to make it obvious what the issues are for and against, what the two sides are, not to take anybody's particular side, but to give right in the middle what is the likelihood of success here. And then they can make their decisions on that.
And you spoke kind of three main pillars there. What are you looking for when you see a duty breach or breach of duty?
Standard of care and reasonableness. There's two things in that. There's a standard of care, and that has to be in the context of a time and a place. So you mentioned birth problems there. That could be 20 years ago, and the practice 20 years ago and the practice now may or may not be different. So you're looking at the standard of care which was acceptable at that time and reasonable in the circumstances. We're not perfect. I'm not perfect. Nobody's perfect, although some people seem to think you should be. So you have to look and say, was this reasonable in the circumstances? And that's the duty of care. So you're looking at standard, reasonable in the circumstances, and then you're looking for, did that really fall below what should be expected?
And what is exactly the but-for test?
Well, if you're saying, but for what happened, would this have been the outcome? For instance, if I give you a case, somebody falls and breaks their wrist, you get a scaphoid fracture. And sometimes in NA, let's face it, they're rushed. They don't x-ray, or they don't see on x-ray a scaphoid fracture. And sometimes the fracture doesn't show up for 10 days. So you get it acutely, it's not there. So they might wrap it up and send it home and say, look, if it's still painful, come back. Or the GP says, I think you should go back and get x-rayed. So about a week later, they'll come back and get x-rayed. And then the fracture will be there, which was missed the first time. They said, here, I wasn't putting a plaster last week. That, therefore, is a breach of duty, and, I'm going to sue. Then you look in the future and say, and the problem is 1 year later, I have difficulty holding a pot of tea in a kettle. It still hurts my wrist and things. You say, no, that's because you fractured your wrist. That's nothing to do with not being in a plaster. So, but for, it has to be but for what happened, the lack of plaster for a week, this is the consequence. And in that sort of issue, it's not the consequence.
There seems to be, we have a couple of cases here on consent and informed consent. Couple were procedures where people consented to one part of an operation and came out and something else happened. How important is informed consent, and how I suppose regular does it happen that people have operations where consent is questionable?
That's a very interesting thing in especially in your jurisdiction, because there are two types of consent forms that I regularly see. One says the following are the risks that have been discussed, blah, 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 blah. And another one says, I consent to anything and everything the doctor said, and they sign on the bottom. And you've no idea what was discussed with the plaintiff or the patient. And that's a problem. And it's a problem with consent forms in certain major hospitals in the south. In the north, changed a long time ago in the UK jurisdiction to a better sheet. You've got to list out the main risks, which are of consequence to the patient. Not nearly everybody could die, right? And that's just not something you want to push on people. And you don't want to push consent to the, and list out every risk to the extent that nobody wants to have any surgery anytime for anything. But on the other hand, you have to lay out the risks which would be of consequence to the patient. For instance, a singer might want to know if you're working on their throat, that you may change the tone of their voice. That's important to them. And if it's only for nodules, they'd say, okay, that's what you want to do. What happens if you do nothing? If you don't do anything at all, what would happen to me? Are there any alternatives? Do I have to have it now and can I wait? Are there any alternatives to doing it this way? So they therefore, because the paternalism bit has gone low, I have to say a lot of patients will come and say, look, doctor, whatever you think is best, which is a problem. Because you're saying, well, look, you've got to think about this, But a lot of patients say, doctor, I don't know any medicine. You tell me what's best, and I'll put my trust in you. It's funny how that trust sometimes gets broken a bit later on. So the kernel of informed consent is telling the plaintiff what they, as a person, would attach importance to know. Now, the other side of that is sometimes said, well, you didn't tell me, for instance, if you did a colonoscopy, a look into the bowel with a telescope, that it could perforate. From a court's point of view, they look at it and said, well, look, what happened was they did, you knew they were biopsying for cancer, you knew they were taking this, nobody actually said you could end up with a stoma bag, right? But had they done that, and you knew that they were looking at you from a point of view of a cancer of the bowel, would you have gone through with it anyway? And if it comes out the answer is, well, yeah, you would have, then you're saying, well, what was the consequential damage of not being told? So in informed consent, there's that twist at the end said, had you been told of this specific thing happening, would you then have refused the procedure? Or would you have had to have it anyway because of the underlying condition? So it's not straightforward. You didn't say infection, I got infected, it's your fault from consent. Does that make sense?
Yeah, and does that consent always have to be written? Does it have to be written consent form?
Depends on the procedure. For taking blood, supposedly you should be told, look, you can bruise, but you put your arm out, it's implied consent, said we're taking bloods to look at your cholesterol or something, it's implied consent. So no, all consent's not written. Dentists don't have written consent.
Sure.
but they should have something or leaflets or something that tell the patient what they're likely to expect and answer their questions.
And when does a complication in surgery become a question of medical negligence?
It comes down to the standard of care.
Okay.
Everything is complication. Everything that I or anybody else does, every tablet I give you has a side effect. And if you look at the books, the side effects as long as your arm. Most lawyers will look at the book and say, oh, look, they can be dizzy, they can, drop off a cliff, all sorts of things. Every drug has a side effect. What you're hoping is the main effect is better than the side effect, and that, 90%. But if you reckon that if a client comes to me and 1% of clients don't do what I think they're going to do, and I see a couple of hundred people a week, 100 to 200, that means 1 or 2 people per week don't end up with the outcome that I thought they'd end up with, 50 a year. Now that builds up. Nothing is perfect. So a complications happen, you should be warned. But that does not mean that negligence didn't occur.
Yeah.
It comes down to the standard and whether there was a breach of the standard, whether people were properly followed up, whether the right monitoring was done, etc., etc., etc.
I was having a look on your website there the other day. It's actually a great website, rodneypeyton.com. And you discuss a lot about whiplash. Now, whiplash is obviously, in Ireland, the personal injury guidelines, they came out in April last year, and a lot of the personal injury awards have now been greatly reduced. And whiplash is kind of one of those which is caught up because it was always on that tariff of award that a client might get. But what's also happening is there's a huge question over whiplash in a road traffic accident where, it's just a tip. Say someone is at a T-junction and they're stopped, and someone might be coming into the back of them, slowing down. So they might only be traveling 10, 15 kilometers an hour, even if that. But the impact does, and I've had clients where they have suffered severe soft tissue whiplash injury with an impact of that vehicle traveling that low. Like, are those injuries real? Like this is always comes to question, because an insurance company will say there's no way the person could have suffered that injury. This is an exaggeration or it's a lie, when in reality it's not, because the client has been suffering.
Yeah. Fundamental dishonesty, let's get rid of. That's blatant. That's doing something.
Yeah.
Exaggeration comes along because everybody's different. For somebody, they may have a bit of a prang in the car. For somebody that had the worst, it was a bomb explosion when it hit me, and it could be the same scenario. If you look at things from different points of view, it comes from the point of view and the mental set of the patient, how they feel at the time. So there's a lot of psychological issues in this. But the question you're asking is, can you be hurt from a low impact injury? Now, I start from the point of view, one, you believe the client in front of you. They start with 100%, and from my point of view, they lose points. And you listen to the story. Now, it's a fairly they're hit. They mightn't be painful at the time. If they're painful at the time, that really should be a large hit, but they might get painful because a whiplash is not a medical diagnosis. A whiplash is a musculoskeletal strain injury to the neck, where you've got a tight band around your neck of fascia, and inside the muscles swell because they've been injured, and that swelling then causes a lot of pain. Okay, most of the time that's what happens. So it may develop over 24 to 48 hours. It usually comes to a peak in a couple of weeks, and then it gradually dies off. It should not be getting worse over time. And when you see them at 6-9 months, they're even worse than they were before. Now, who's most likely to get it? Women, people with long necks, older people who already have degenerative change or problems with their neck in the first place. You are exacerbating a pre-existing problem. So when you look at that, as opposed to a 14 or 15-year-old with a supple neck. Secondly, if you think about the mechanism of the accident, a driver who's holding onto the steering wheel and sees this coming and hits at low speed and is tensed up is less likely to have a problem than somebody who's sitting behind down on their phone and hit. And because they weren't ready and because they weren't hit, they're thrown forward. right? And so you get a paradox there. Because like bumper cars, people say, well, why do you get hurt in a bumper car? It's like, because you're waiting for it. You know, you can't get hurt in a bumping car. If you look at the wall, it says, if you've got a neck problem, don't ride this ride. But most people laugh and they're holding and they're tensed and they're ready for it, and it's very low impact. Okay, because they're ready for it and they're stabilized. But if you're not stabilized, then you know that as the speed goes up, if you're stabilized and hit at high speed, this more rips. Whereas somebody who's loose and elastic goes forward and back, they may be less likely to be injured than the driver. So you have to think about the mechanism of injury, whether it was straight on, whether they were twisted, whether it came from the side, what their age group is. There's lots of it. If the car moves forward and they say, I went forward 20 feet, say, good, because that took the momentum off. If they had the handbrake on their foot and the brake and it hit, it's like going into a brick wall. So that's totally different. You put your fist into a brick wall as opposed to into a pillow. You know, one's more liable to hurt than the other. So there are all sorts of circumstances. And when you're doing a medical legal case, you're looking at those circumstances of what exactly happened, the mechanisms of injury, things about your client. And then you go down to the examination. And there are various tests, we call them, but they're not really. There are various things that happen. I mean, if somebody if they can, you say, can you lean forward, let me see how far you can lean, and they can't. Oh, I can't. And they lie in the bed and they can hardly lift their legs off the examining couch. And then you say, let me see your back, and they sit up fully. You look and say, there's something wrong here. Okay. Now, one swallow doesn't make a summer. But if you get multiples of these, then the suspicion rises. And as I say, you start at 100%, each one of these starts to drop. Okay? Until you say that, you know, I can't explain this on a purely physical basis. So the answer to your question is, can you be hurt at low impact? Yes, you can. Anybody who's played sport who has been not expecting something, walking up and somebody hit them from behind, knows they jerk their neck back. Well, how long does it hurt for? A week? You know, they're back playing the next week. Those are young people. But if you do that to somebody older, push them in the back, you can't hurt them. So to say you can't be hurt is a nonsense. But then you have to look at the context, have to look at the story, have to look at the history and what has happened since to see, does this fit? Yeah. And if it doesn't fit, then it's not for me to say somebody's exaggerating. That's for the court. What I can say is, this is what I find. I can't explain it. And if you want to take that, let the judge look at it.
Yeah, and then I suppose the judge makes the decision. Yeah, the minimal impact defense. I've seen a lot with insurance companies where they say, look, the car was traveling so slow it couldn't have caused the injuries we say.
Well, if they've turned up at the doctor the next day, if they've had physio and the physio has followed them for 6 weeks, and you can see in the physio today, the next day they're a bit better, the next day they're a bit better. It follows a pattern which is reasonable.
Yeah.
How do I know? You could tell me you got a headache at the moment. I don't know. But I can see how you're reacting and say, is it likely or not likely in my estimation? And I've seen thousands of them.
Mr. Peyton, thank you so much for your time this morning. Just one last area I'd like to discuss was the issue of statute. Because in medical negligence, it's slightly different from a personal injury case, say in a road traffic, where the clock starts in Ireland, the 2 years starts from the date of the accident or the first occurrence of the injury. Where in medical negligence, it's from the knowledge of the injury or the knowledge of the negligence. Have you seen, how does that play out in your experience?
Well, some are obvious. Now, let me just give you a recent case, change it around a bit. But here's a young lady who was involved in a road traffic accident when she was like 16, and she fractured her pelvis. She couldn't pass her urine. They went to put in a suprapubic catheter above into the bladder to drain it because she couldn't pee and she couldn't sit up. And when they did, and they took the thing out, they found that they actually had cut with the trocar. They cut the end of the catheter and it was left behind. Okay. They knew about it. They told her and they told her parents at the time, right? They did a laparoscopy for other reasons, slightly, later on in that to make sure she wasn't bleeding. Saw nothing. The urologist looked in and saw nothing. And the CT scan didn't show it. It was all swollen because of the fractures. Then she got lost to follow-up. But they knew that was there. Some 20 years later, she develops appendicitis, right? And she gets a CT scan. And the CT scan shows the remains of the catheter just sitting in front of the bladder. So she sues and says, well, look, that caused my appendicitis. And when they went to take it out, they caused a nick in the bladder, which had to be sewn up. And I now have psychological trauma, et cetera, et cetera. And you're saying, the statute plays out there. The parents knew and she knew 20 years ago, and they knew it wasn't taken out. Yes, it wasn't followed up at that time, but then she became 21. Then she's gone on that number of years, and she's out of time. That the catheter tip was left behind is true. That she had to have surgery to take it out is true. But the date of knowledge was 20 years ago. So that's not going to run.
Statute expired. Interesting, isn't it?
So that's where we come from in that.
Thank you so much for your time. This has been a fascinating conversation. If solicitors, medical negligence solicitors, are watching this or listening to this, what are the particular services you could provide for them? Why would they contact you?
Well, the first one I've told you is about getting that screening done.
Yeah.
You have a system. System saves yourself stress, time, energy, and money. That's what system stands for. Yeah. And before they lay out, I've seen solicitors say, that's obvious. They become emotionally involved with the client. That's a bad start. Empathy is one thing. Emotion is not good. You have to look at it coldly and say, look, I will look at this quickly and efficiently. I'll get somebody. So we're not going on for 6 months till I find out the case. I'm going to do it the next week or two. I can then give you a hint as to whether it's likely, not likely, or we need to look further. And for instance, somebody doing no win, no fee, before they spend a lot of money, you want to get a quick screening oral done. Then from their point of view, they can say, my company, the risk is we're not taking it on, but you've plenty of time to go to somebody else if you wish.
Yeah.
So you're, as a lawyer, not on the hook for running them out of time.
Yeah. You're
getting a quick opinion, which is yes, no, or maybe. And on the basis of that, you can then make decisions, especially if you're doing no win, no fee. So the service is screening.
Yeah.
It's effective, it's efficient, and it saves a lot before you go into depth. And then when it's done, you can say, look, the people you need are a cardiac surgeon, you need a vascular surgeon, you need this. Because sometimes lawyers think, that's a knee, it's an orthopod. You said, no, that was a vascular injury, it's a vascular broke. And you've just spent money for someone to tell you they're the wrong person.
Yeah.
So it's about saving yourself time, energy, and money, your own time, energy, and your cash.
And is there a particular area of medicine you take those cases on, or is it general?
Screening is general.
Okay.
Because if you look at my website, I have a wide general training just because of the way it is. Because screening is not the last word in court. It's not for the court. It's for the client and it's for the lawyer so that they can start to make up their mind. Then they need to go and get the depth ones for, court purposes or taking it further if it looks as if that's going to succeed. It's worth the money.
And how can someone reach you? What's the best way to contact you?
DM on rpeyton@rpeyton.com, or if you look at my LinkedIn profile, and she said yourself on the web, but rpeyton@rpeyton.com, it's on the bottom end. Or if you look, I publish every month in Global Law Experts. So it's the first one on there, and there's a med-neg case and discussion of the medical aspects of the case every month on Global Law Experts.
Well, Mr. Peyton, this has been a fascinating and interesting conversation. Thank you so much for your time, and we wish you all the best for the future.
Appreciate it very much. Thank you for asking.
Take care.